Hello, I'm David R. Schneider, estate planning attorney. I'd like to thank you for tuning in to watch our series of videos on estate planning basics. This video will discuss the needs of disabled persons, dealing with conservatorships, as well as special needs trusts, and the problems that families face when they have a special needs beneficiary. When talking about special needs trusts or conservatorships, we are largely focused on our beneficiaries who are incapacitated. When we have a family that has a child or a beneficiary who is suffering from a disability, typically something like autism, Asperger's, Down syndrome, these beneficiaries are incapable, in the large majority of circumstances, incapable of inheriting from their parents. They can be taken advantage of. Their use and understanding of the assets is compromised, and we need to protect these individuals. Furthermore, many of these individuals are receiving different governmental benefits. The process for receiving these benefits through the state of California or through our federal programs are all wealth-based, meaning that the persons that sit at essentially what is the poverty level, they qualify for the use of these benefits. Now, your child who may have, let's say, as an example, autism, is already at the poverty level because the parents own all of the assets. The child doesn't own the assets, so the child can qualify for these benefits. However, if when the child reaches the age of majority, the age of 18, and the parents, should they subsequently pass away, if the child inherits, now the child will no longer qualify for these benefits. This is where we use something called a special needs trust. The special needs trust is a vehicle to hold the assets that that beneficiary might have inherited and have them controlled by a trustee. The trustee can use those monies for the incidental needs of the beneficiary, but the main care of the beneficiary's source of housing, source of the facilities and benefits that they're receiving are all paid for through the governmental resources. This prevents any government agency from making a claim or a statement that that beneficiary actually has these assets and thus disqualifying the beneficiary from the assets. The special needs trust designs a payout such that when the special needs beneficiary passes, whether that is in the near term or the long term, the trust will then provide these remaining assets, those that are not used for the benefit of the special needs beneficiary, to what's called the remainder man, our successor or contingent beneficiaries. Typically going to be other members of the family, the brothers and sisters, could be charity. It is really whatever you wish for it to be. Often used within the same program or the same sets of circumstances is something called a conservatorship. A conservatorship is a court proceeding that is utilized to name a conservator, a person to be in charge of our special needs person, in this case called a conservatee. This is a required process when our special needs beneficiary attains the age of 18, the age of majority. The state of California, as well as the other states, all consider a person age 18 to be an adult. Now we have to put an apparatus in place to speak on their behalf when they can't speak for themselves. This is the interactions with doctors, with healthcare providers, with social situations. When our conservatee, our special needs person, cannot act on their own and they cannot communicate effectively with these other agencies, somebody needs to act. This is a conservator. This is a court proceeding where the court will investigate, vet, ensure that the conservator is the right person that has the conservatee's best interests in mind. There are two types of conservator. There's a conservator of the person and a conservator of the estate. The conservator of the person handles things like educational decisions, healthcare decisions, social and life decisions. The conservator of the estate is in charge of any of the conservatee's assets or money. Now, when performed in conjunction with the special needs trust that we just spoke about, we can sometimes have a proceeding without a conservator of the estate. If the beneficiary is not going to receive any of the assets in his or her name, perhaps they're only going to receive Social Security disability, a conservatorship of the estate is not necessary. The Social Security disability income can be paid directly to the conservator as what's called a payor status, and then the payor would use those monies again for the benefit of the beneficiary. This can be a very detailed and difficult discussion with families that have beneficiaries that qualify in these ranges. So please give me a call for a further detailed discussion about your particular needs. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call, David R. Schneider, 805-374-8777. Or please visit our website at drs-law.com.